All right. Thank you all for joining us this evening. This is our first of 4 board education series events this year. And we like to kind of do one of this nature right around this time each year because all of you have had your annual meetings, or most of you have had your annual meetings. For the majority of our communities, annual meeting season seems to run October through March. So we catch all of our new board members this time of year, and that's kind of what the intent is. But this is always good information for any board member, regardless of how long they've been on the board. Right. Start us off tonight. We're going to talk about the purpose of a community association. So for years and years in the industry, it's kind of a common knowledge that community associations exist really for 3 purposes: to preserve, protect, and enhance. I'm going to go ahead and reiterate that because I did mention that, we do have gift cards for some trivia at the end of this tonight. So it's important to remember a few things, and I'll try to point those out along the way. But community associations exist to preserve, protect, and enhance. Really, the mission of every community association should be to preserve their community's development plan and overall appearance, to protect property values, and you do that by properly maintaining common areas and enforcing your governing documents. And then enhance aesthetics and overall experience in the community, which you do in a number of ways: maintenance and upkeep, improvements and renovations, and community events, of course. By the way, I didn't mention this at the start, but this is interactive. If you have questions along the way, feel free to unmute yourself or put a question in the chat. I'll do my best to answer those as we go, but if I don't get to them before the Q&A at the end of this, I'll address them during Q&A. Let's talk a little bit about characteristics of community associations. So by and large, community association membership is mandatory. If you buy a home in a community association, it's not an option, you're a member. I say it's mandatory for all owners, mostly because there are still some voluntary associations out there, believe it or not. They're not as prevalent here in Arizona as they are in other states, but they do still exist. For anybody who is aware of any, they don't do much and they don't really have a lot of money because nobody voluntarily pays assessments, really. So those are communities that maybe have a monument and a little strip of land out front, and how well that gets maintained is based on who's willing to throw some money in the pot at the time. All community associations have governing documents which contractually bind owners and create your obligations, powers, and restrictions for both the owners and the association. I'd like to reiterate just real quick that the governing documents contractually bind owners. What a lot of people don't understand is that HOA law is really contract law, because the CC&Rs are a contract with the owners. And so anytime HOAs have to go to court, whether it's in defense of themselves or whether they're the plaintiff, it is a contract law case that is being disputed. Associations have mandatory lien-based assessments. Those assessments are secured by a statutory lien. These days, there's a new term for it called the common expense lien under statute, but it is still a statutory lien. That lien exists on everybody's home. If you live in an HOA, you have a lien on your home by statute. When we record a notice of lien, all we're doing is recording a notice that the lien exists, because it already exists. Assessments are levied against all owners in the community, and they're used to operate and maintain the community association and fund for your major repairs and replacements. Some more community association basics. This is your hierarchy of governing documents. Probably shouldn't come as a surprise, but federal laws supersede everything else, then state statutes, and then local ordinances. When we get to your actual governing documents, your plat map is really the highest document in the hierarchy. Plat maps rarely contain information that you need to reference, but occasionally you will find some maintenance obligations in your plat maps. This tract of land is maintained by this party. And so when those things exist, it's important to understand that, because that is your top document in terms of hierarchy. If anything below that ever conflicts with the plat map is the ruling document. By and large, everybody refers to the declaration or CC&Rs as your controlling document, because it's the Bible for the association. It details what restrictions exist. It details how everything is going to operate, and it is the highest of the non-map documents, if you will, in the hierarchy. So again, it overrules everything below it. That's followed by the articles of incorporation, then the bylaws, and then your rules and regulations. Your articles of incorporation, if you didn't know, really just detail how the corporation, that is the association, is going to be set up. What's the initial board going to look like? How many, it might detail some of the same things as the bylaws, how many people are going to serve on the board, etc. The bylaws really talk about how the board is going to operate, what authorities does the board have, how many board members are there going to be, all of those types of things. Then, of course, the last thing in the hierarchy are all of the items that the board actually has the control to change without homeowner approval. Your rules and regulations, your architectural guidelines, your board resolutions, those are all bottom rung in terms of the hierarchy. That does not mean they're any less enforceable, but they cannot conflict with anything above, or those documents take priority. A little bit more on the community association basics. We'll talk a little bit about this again towards the end of the presentation, but as a board member, you actually have an obligation to enforce your governing documents. Enforcement, and that doesn't mean necessarily just enforcement of restrictions homeowners must follow, but enforcement of your governing documents is not a choice. There is case law out there that says you have to, the case law that has been set at the Supreme Court level, that says you have to enforce your documents. Basically, you have to enforce or amend. You can't just ignore. And so we'll talk a little bit about more about that later, but that is something that everybody needs to understand. It's also really important to understand the responsibilities and authorities of the board versus owners. For anybody who served on their board for any period of time, you probably know that from time to time, homeowners show up at board meetings and think they have the right to vote or want to bring up topics when they're not on the agenda. And it's just simply because they don't understand their responsibilities and their authorities versus those of the board. But the simple fact of the matter is, in most governing documents, homeowners only have a few authorities, and those authorities are to elect their board members, to vote on governing document amendments that require homeowner approval, to vote on assessments above and beyond what might be allowed in the governing documents, and to vote on any sort of special assessments, or to recall the board if they want to go through that process. Aside from that, though, the authority for every other decision rests with the board. The board is the party who has, some legal liability in those decisions and has the obligation to act as a fiduciary for the association. It's also important that everybody who serves on a board understands conflicts of interest. Arizona law calls out specifically what a conflict of interest is for HOAs. And essentially, for HOAs, a conflict of interest is any decision you might be making that you or really any member of your family would financially benefit from. In the law, it lists out spouse, parents, children, in-laws, grandparents, it goes, or any of their spouses. It goes into great detail, but realistically, it's anybody you're related to if they have a financial gain. So you have a sibling who owns a painting company and you're bidding, painting of the walls in the community. You could bid to them, but you have to disclose that conflict of interest at the beginning of the meeting. And this will be mentioned twice because this is an important note today, but you're not required to abstain from the vote. Matter of fact, you can participate in discussions and in the vote under the law. We will tell you that it's best practice that you abstain from the vote if there's a conflict of interest. It's just a better overall look. But the law only requires that you disclose that. I'd like to touch a little bit upon disruptive owners and how we deal with them. Disruptive owners, come up from time to time, but the truth is, if you're communicating effectively and giving everybody ample time to state their case, it doesn't happen often, but it does happen. When it does happen, what you should expect in terms of dealing with them is a couple things. If you're having a virtual meeting, it's really easy. Obviously, you can mute them. If they continue to get disruptive, kick them out. When you're having an in-person meeting, it becomes a little more nuanced. So you ask them to come to order. You remind them that there's appropriate times for them to speak. And if you can't get them to come to order, you ask them to leave the meeting. And if they refuse, quite frankly, you adjourn the meeting and hold it again at a later date. That's how you deal with it. You deal with it by behaving professionally and just acting through that step. And your manager should help walk through those steps accordingly. Removal and replacement of board members, I mentioned earlier, one of the authorities of homeowners is to recall the board if they're unhappy, or certain board members. They don't have to recall the entire board. There's a process under Arizona law for homeowners to recall a board if they're, or board members if they so choose. That process requires getting signatures from a certain percentage of the community, followed by on a petition. And when that happens, the association then has to call a recall meeting. It's not an option. In fact, under Arizona law, if that recall meeting is not called within 30 days of receiving the petition, then the board members who were listed on the recall petition are automatically removed. So you have to call and hold that meeting within 30 days. And at that meeting, so many homeowners have to vote in favor of the removal of those board members. If successful, a secondary meeting then must be called and held after that to elect new board members. So that's the process if homeowners wanted to go through removal of board members. Now that we've covered some of those high-level basics, let's talk about some standards for board members. As board members, you'll find, if you don't already know, that associations and boards as a whole are governed by 3 different set of state statutes. These are important to note for later on. Those are the Planned Community Statutes, the Arizona Condominium Act, and the Nonprofit Corporation Act. All 3 of those oversee associations. Obviously, the Condominium Act is specific to condominiums. The Planned Community Statutes are specific to HOAs that aren't condos, your single-family homes, many of your townhomes, unless they're designated as condos. But Planned Community Statutes, and then the Arizona Condo Act, and then the Nonprofit Act governs both as well. As a corporation, HOAs are considered a nonprofit corporation, not a nonprofit in the tax-exempt status, but nonprofit in terms of how they operate. So the Arizona Nonprofit Act does talk a couple things about how boards should operate. And one of them is directors' duties, including their duties as a member of a committee, have to be discharged in good faith, with the care an ordinarily prudent person in a like position would exercise under similar circumstances. We'll talk about those 2 in just a moment. And in a manner the director reasonably believes to be in the best interest of the corporation. So you put those together, and what you get, in good faith, you're making decisions that you are making because they are going to benefit the community. They're not going to benefit you individually. You're taking the care an ordinarily prudent person would take. In other words, you got a proposal for $50,000. You probably should have at least 3 proposals for something of that magnitude, right? You should be doing due diligence. That is the care an ordinarily prudent person would take. It's part of the reason that most of our communities, a couple chose not to adopt it, but most of our communities have proposal procurement policies that dictate, when we're going to get multiple proposals. And then, in a manner the director reasonably believes to be in the best interest of the corporation. As a board member, as a board director, you have an obligation to act in the best interest of the corporation, that is the association, not in the best interest of your neighbor or you as an individual. And so those are important things to know as you're operating as a board member. This is also really important, not just for later, but just to know in general, but it is important for later. But same statutes, the Nonprofit Act, also talk about when you're discharging your duty, you have the right to rely on information, opinions, documents, etc., provided by really any of the following: another officer of the corporation that you think is reliable and competent in that matter, any professional, so your legal counsel, your CPAs, a consultant you hire for asphalt, an engineer you hire to look at your buildings, you have the right to rely on their expertise and their professionalism. And then you also have the right to rely on a committee that you have appointed if you believe that that committee and their what they've come to you with merits confidence. If you're making decisions relying on information from those types of individuals or groups, you are protected should those end up being the wrong decisions. This is referred to as the safe harbor or business judgment rule. Again, important to remember those terms, safe harbor or business judgment rule. By operating in this matter, you have safe harbor. If somebody were to sue you for a decision you made at the advice of your attorney, or because you listened to a committee you put together to do research on something, they can sue, but you as an individual are going to be protected. Even if they name you, you would expect that your name be removed from that lawsuit, and the lawsuit only be against the HOA, because you have followed the safe harbor and business judgment rule. You have not taken action that would otherwise be against your experts. The only time as a board member you should ever worry really about having a personal obligation is if you are knowingly going against your experts. If your attorney tells you you can't do this and you do it, you will open yourself up to personal liability. You will also open the association up to not being covered by insurance for those decisions. So it's important to know that you need to follow your expert's advice. Right. Let's talk a little bit about the roles of board members. Every annual meeting, you'll hear myself or one of your managers go over, well, after the annual meeting, go over what the officer positions are and what their responsibilities are, and we'll touch on them this evening. But by and large, the president is the individual who helps set the meeting agenda. They preside over the meetings or turn that over to us. They sign contracts, resolutions, really any document that doesn't specifically require the treasurer or secretary's signature. The vice president, their job, if you read most governing documents, is solely to act in place of the president in his or her absence. The secretary, technically in most governing documents, is responsible for noticing meetings, keeping meeting minutes, recording votes, sending out notices for your annual meeting, all of those types of things. The secretary's duties are largely transferred to management contractually, and so the secretary really should be the person who's, helping with notices, most closely scrutinizing minutes, things of that nature. Similarly, the treasurer's duties are largely passed off to management as well, but the treasurer technically is responsible for receiving and depositing funds, setting up and maintaining bank accounts, preparing financials, preparing the annual budget. Again, most of these things get passed off to management, but the treasurer really is the person who should probably be most closely scrutinizing the financials and paying attention to what's going on financially. As mentioned here, your governing documents will spell out the exact duties of all officers, but most governing documents pretty much spell out what we've put up here on the screen for you. All right, let's talk about some characteristics of successful boards. Successful boards listen to their community members, their management company, and their industry experts. We've already talked about listening to your experts. In terms of listening to your community members, we're big fans of surveys when appropriate. We have a community, I think we might have a couple of the board members on this evening, but who is just finishing up a survey because they're looking at revising their rules and regs. And, there's a couple questions that were put out that, 75% of homeowners who responded were in favor of One Direction. And it's this community's 800 homes, and almost 300 homes replied to the survey. And so, 75% of respondents being in favor of that direction, it'll probably be our recommendation that the board go that direction. You sought their opinion. You got a pretty overwhelming response. You should listen to your community members when you can. Successful boards also operate in one leadership voice. This does not mean that you have to agree on everything unanimously as a board. But if you're in a board meeting and you vote against something and the rest of the board votes for it, when it passes and you leave that room, you have one leadership voice. Your your stance on that should be the board decided this is how we're going to move forward on this. This is how we're moving forward. It shouldn't be, well, I voted against it, but the rest of the board members voted for it. That creates divisiveness, that creates problems that don't need to exist. Your name will be recorded in the minutes as having been opposed, but you have to operate as one leadership voice when you're on a board. Successful boards understand that they are a fiduciary. You have a fiduciary responsibility to act in the best interest of the corporation. As we mentioned already, this means separating business from social matters. Again, some of the decisions you have to make might be in the best interest of the association, but not even in your personal best interest. I'll give you guys a quick example. We have a community in Tempe that has an RV lot, and one of the board members stores their RV there, and the board voted this year or at the end of last year, to raise the annual lot rent in the RV lot, which is quite reasonable, but to raise it to something to give the association a little more income. And that board member abstained because they knew voting against it for their own personal benefit wasn't the right move. And so that's what it means to have fiduciary responsibility, to separate business from your personal or social matters. Meeting preparation and conduct, successful boards come ready at their meetings. They've read their board packets. And don't get me wrong, this also means you get your board packets on time so you have time to review them. But they come prepared, ready to make decisions. They try to be efficient, conscientious, and professional in everything they do. Ask questions in advance so the meeting can flow smoothly. I think we all know it doesn't really matter the industry. Studies time and time again have shown that meetings over 2 hours become unproductive. Our contract calls for 3-hour board meetings because I know that often open meetings go 2 hours and you need more time for the executive meeting, but we'd really love to keep the combined meetings to 2 hours whenever possible. And that requires a little bit of preparation and partnership in the board to make sure that happens. Successful boards also understand that they are servant leaders. They strive for harmony and unanimity within the community. They understand that they're responsible for other people's biggest investments and castles, so to speak, and they seek to serve the members of their community, not to feed their own personal agendas. It is not uncommon for board members to get on because they have one issue that is driving them to get involved, and that is fine. But at the end of the day, when you serve on the board, you should be seeking to serve the entire community, not just that particular item. They also view themselves as temporary stewards of the community business. In an ideal world, nobody has to be on the board forever. Your job while you're there, though, is to be the best steward you can be and leave it in good shape for the next. Successful boards also develop and facilitate processes that can easily be transferred to and carried on to future board members. This is part of what we do too when we take over communities. We want to make sure you have the best practice policies in place, that things are clear on how they should be run. So when the board does turn over, some of you are on boards that are up for election every year as a whole. We much prefer I would call it the more traditional method where you have, 5 people in 3-year terms. So no more than 2 people are up for election in any one year. But some of you are on boards whose documents mandate everybody be up for election every year. So, heavens forbid that one year everybody gets voted off the island, so to speak, and a whole new board's in place. They need to be able to pick up and continue with things. And so that's what's important in terms of facilitating and developing processes that future boards can carry on with. And then this one's always easier said than done, but empowering others in the community and building strong relationships. Empowering others could mean creating committees. It could just mean empowering others to take action. We've all seen on our neighborhood Facebook pages or nextdoor.com, somebody complained because, there's trash in the corner over here by the monument that they could have probably picked up when they walked by. But nonetheless, it's just getting people to understand we're all in this together and we all need to work together. Successful boards work on building community. This does not necessarily mean having community events, although that helps, but communicating and collaborating with other organizations. every municipality from a police department standpoint has a community liaison who's the person you're supposed to go to as a community with issues and get them involved. You strive for positive resolutions to community and owner issues. I always like to say, one of our mottos as a company is solutions today, plans for tomorrow, but that applies to homeowners too. Let's find a solution. I tell my team all the time, let's find a solution. A solution isn't necessarily one party getting their way. It's what can both parties live with, what makes sense for the board that they can negotiate on and that the homeowner will be okay with, even if neither party gets their full way. Regularly and publicly recognize and promote community volunteers. We like to help in this process at annual meetings, calling out, anybody who volunteers and thanking them for their time, including you as board members, but regularly and publicly recognizing anybody who's helping the community. Develop and implement and publicize corporations' vision through short and long-term planning. I think anybody who sat through a presentation when we came on board to a community or when we were giving our proposal, we say we like to handle your day-to-day business so you as a board can focus on big ticket items, long-term planning, and community engagement. So our hope is that you can do some long-term planning and be able to publicize a long-term plan of here's where we're wanting to go over the next few years and here's how we're going to get there. And then emphasize respect, reasonableness, and community harmony. Again, none of this is rocket science. None of this is, the end of the world. We're not talking about things that are going to land people in jail. We're talking about things that we need to find solutions to and be reasonable about. Successful boards also understand that their staff and vendor relationships are really partnerships or need to be for the community to be truly successful. So they view their vendors and staff, if applicable. Many of you don't have actual staff, but if you do, view your vendors and staff as partners and team members. Treat everybody with respect. Establish and follow proper protocols for working with vendors and staff. Maybe you have a landscape liaison who's the only person who should be really communicating with the landscaper so they're not being inundated and overwhelmed. Rely on your vendors and your staff to give you analysis, give you recommendations, and then to implement your decisions. And understand that your vendors and staff also have their own protocols and processes. We're going to talk in a little bit about committees and how they can become a benefit or a nuisance, but I'll kind of talk about one right now in landscaping. Both boards and landscape committees have a reputation for pulling landscapers off what they're working on to work on something else, and that puts them behind their own maintenance schedule. So let them work through their own schedule, follow proper protocols for communicating and bringing things to their attention. Now, obviously, that doesn't mean, hey, we have a major leak over here, we shouldn't go tell them right away, but while they're on site, but pulling them away from the area they're working in because you want a shrub trimmed on this corner over here, not the best use of their time typically. That leads into the management partner, which is us. Talked about a little bit of this already, but we act as your business partner. We are the liaison between you and your owners. In an ideal world, you're directing owners to us and not trying to communicate with them individually. You are volunteers. That can get overwhelming and daunting. They need to come to us, understand that we have timelines for response. They're not necessarily going to get a response within an hour, but they'll get one within a couple business days. That's our policy. And let us carry out your day-to-day operations. We will provide you analysis and guidance. Hopefully, anytime you have, proposals in your board package, you're getting comparison charts, you're getting a recommendation, all of those types of things. But at the end of the day, you're the decision makers, and we will carry out whatever decisions you as a board make. If we think you're making a decision that is a liability, we'll let you know and help you understand the risks, but it's still your decision to take on what risks you're willing to accept. Some of you have seen this, some of you have not. If you haven't, you will this year. All of our contracts in the last 6 months have included an Exhibit D that talk about manager time commitment. And this year, as we go into budget season and we give you all new Exhibit A's, we're also going to be providing you a couple of exhibits you may not have, one of them being this Exhibit D, that details out for you based on what you're paying, how much of your manager's time you are paying for and what you should expect out of that time. This is just one example up here. Some pay for less, some pay for more, but if you're not paying for a full-time on-site or dedicated manager, you're paying for a portfolio manager, which means you only get a portion of their time. And so the best way we can partner with you is for each party to understand how much time you're paying for, where that time is spent, so we can be respectful to each other, so your manager doesn't get inundated because they do have limited time and they don't work 24/7. We usually will tell you this is how much time is spent on tours, whether your tours are weekly, monthly, every twice a month, whatever your schedule might be per your contract, how much time spent on action items, working on your board packet, working on email and phone call correspondence, etc. So you understand that, if you start inundating your manager with extra emails all the time, we've had to have conversations with some boards, not necessarily any on tonight, about, 100 emails in 1 week is meaning your manager's not getting other work done. They don't have time to respond to all of those emails and get action items done. That's not what's allotted for in their time. And then understanding response times is important as well. Just like with homeowners, we have a 2 business day response time that we commit to. Internally, we shoot for 1. I tell my managers to prioritize board member correspondence. I would hope that most of the time board members would get a response same day or next day at the latest. But 2 business days is what we commit to. We're not perfect. We're not always going to hit that. I don't always hit that. But that's what we shoot for, just so we're all on the same page. And quite frankly, that's pretty much going to be true no matter what management company you talk to, although there are some that have sneaky language about 48 business hours, which is really 5 days for responses. And so, understand those nuances as well. All right, let's talk kind of as a little summary about what resources you have as board members. Your other board members, especially if you're new and you have board members who've been on a while, your other board members are a great resource. Let them, keep you informed on what decisions the board's already made and why, and fill you in when you have questions on things they may have already discussed. Committees can be a great resource. Committees can also be a nuisance. We'll talk about that next. Your industry professionals, whether it's your landscape or any of the listed ones there, attorneys, engineers, etc. Your vendors, such as your landscape contractors and your pool company, they're a great resource for you on anything you need to know on their topics. There are also outside resources available for you. We are doing our own board education series, but there is organizations out there such as CAI, the Community Association Institute, which at this point is international. That's who we get our certifications and credentials from. They also do board education. There's an organization here in the state called AACM. They're more geared towards management companies, but they still do some board education. And then, of course, almost every attorney in this industry has board education classes they put on every year. And so if you are interested in anything of that nature, talk to your manager. They can get you some information from those companies about what events they have coming up. Your governing documents are, of course, a great resource. I don't expect anybody to read through their governing documents page by page, but try to become familiar with your governing documents. And then continuing education such as the attorney education we talked about. And lastly, but hopefully most importantly, your manager. You should be able to rely on us for your knowledge in this industry. So if you have a question, you should be able to go to your manager. Your manager might not know everything right away. They're not experts in every field, but they should be able to go get you an answer pretty quickly and know where to go to get that answer. All right, segue into committees now. We talked about committees, mentioned it a couple of times. They can be a resource or a nuisance, and that's all in how they're set up. Committees are typically appointed by the board of directors. I state here, unless otherwise stated in your governing documents, occasionally there are two committees in particular that once in a while are not appointed by the board. There's some communities in their documents have a nomination committee, and it might have language that says that nomination committee shall be elected at the annual meeting and serve until the next annual meeting. If you have language of that nature, particularly for a nomination committee, and we haven't already done this, you should talk to your manager about creating a nomination committee charter. We have templates easily modified to fit your community's needs, but because you can't prevent somebody from running for the board, so the nomination committee can't go out and say, yeah, well, we want these people on the ballot, but not this guy. That's just not a thing. So what we usually do with nomination committee charters is say, the board is the nomination committee, and anybody who wants to run for the board can run for the board, because you're not allowed to prevent anybody from doing so unless your documents have language that say they don't get to be on the board because if they're delinquent or something of that nature, which is very, very rare. Occasionally, governing documents will also mandate that the architectural committee be elected, although usually that is still an appointment. There are some documents out there that say otherwise. For a committee to be a valuable resource, the committee must have a charter and be given proper direction, responsibility, and limitations. They need to understand what their job is. For landscape committees, the one I like to bring up the most, because they're the ones that, if they go off the rails, it tends to be the landscape committee. If they don't have a charter giving them direction, they just tend to run a little wild, and they start grabbing the landscaper while they're on site and giving them direction that might not flow with what the board wants. And so it's really important that they have a charter, they understand their limitations, and they understand what their authority is. In most cases, any committee serves only to gather information and make recommendations to the board. I say in most cases because architectural committees usually have the authority to approve applications from homeowners. That's what they're there for. It is best practice that any committee be chaired by a member of the board of directors, or at least have a board liaison on the committee. It is required under Arizona law that the architectural committee be chaired by a member of the board. And that's because that committee has decision-making authority, but the only people liable for those decisions are the board. So that has to be chaired by a member of the board, so that board member can go, I think the committee's making a mistake here. I want to take this to the board for the board's eyes. All right, we're going to talk a little bit about meetings. We'll start with board of directors meetings. We always like to say the purpose of board meetings is for the board to conduct their business. This is a corporate board meeting for the corporation. There's often confusion from homeowners who think they have the right to vote, who want to take over the meeting with whatever issue they're unhappy about, whatever that might be. The owners do have a right to comment on any agenda item the board is going to vote on once a motion has been made and seconded and the board has finished its discussion. If the board's not voting on something, technically, homeowners don't have the right to comment on that. Now, if you're okay on time and it's not a contentious issue, it's okay to let some people comment on something you've discussed, even if you're not actually voting that evening. But they don't necessarily have the right to. So if you need to put a stop to it to move on, you're more than welcome to do so. You could also limit them to only 2 to 3 minutes per topic, and you can limit the number of speakers if there's a lot of people wanting to speak on a topic. For all of you, if you're our client, you have a meeting conduct policy, and that policy details all of this already. You also can hold an open forum either at the beginning or end of the meeting to allow owner comments. Not actually required. It is best practice, and you really should hold an open forum. But if there's a particularly contentious meeting you're going to have and you just want to focus on the topics and get done, you're not required to hold an open forum. In terms of board meetings, there are two types, open and executive. We'll talk in a little bit about the reasons you're allowed to go in to executive meeting. At board meetings, it is pretty critical that everybody behave professionally. There's going to be people who show up who get heated, sometimes even board members, but got to behave professionally, have to separate business from social matter, and have to be ready to just Move through the agenda appropriately. Come prepared by reviewing your packet in advance, as we've already discussed, asking questions in advance. Disclose conflicts of interest at the start of the meeting. When we're in executive session and talking about things that are confidential, whether it's attorney-client privileged or just personal financial information about an owner in the community, maintain confidentiality. Refrain from engaging owners in debate. It is okay to have discussion, but the board meeting is not the time to debate why a violation is a violation. You hear the homeowner's comments. You are free to respond, but you're not required to. But you don't continue to have back and forth. And then avoid negative comments about owners and other board members, or anybody really. When you have your board meeting, this is what you should expect out of your board packets. At a minimum, your agenda, minutes from the last meeting, management report, financials, any items requiring your decision or action. So proposals with comparison charts, backup documentation, all of those things under unfinished and new business. Your management report should really be the area where anything that's not ready for your decision is updated briefly. And then for executive meetings, there's also appeals and collection reports. Talked about some of this already, but we're real quickly going to go through the open meeting stuff again. Again, you can conduct a brief open forum at the beginning or end of the meeting. Follow your agenda. The agenda has to be available to owners present. Really, these days, under the law, it has to be sent out 48 hours in advance with the meeting notice, which we'll talk about in a moment. Take proper meeting minutes. Hopefully, we are doing that for you, or some of you actually have a third-party minute taker, and that's fine too. Keep your meetings moving. This is everybody's job, the manager and the board, to make sure meetings don't last more than 2 hours whenever possible. Understand when owners have the right to speak, as we've talked about. Deal with conflicts during meetings. Again, this does not mean debating with homeowners, but if there is a conflict that exists, a conflict with the vendor, a conflict between board members, that we need to deal with that before we leave there so we don't create a divide that continues to grow between meetings. And leave that meeting with one leadership voice, as we mentioned earlier. All right, notice requirements. State statute requires that all board meetings be noticed at least 48 hours in advance. And part of that notice has to include an agenda. This is where we like to take a moment to remind everybody that anytime a quorum of the board gathers to discuss board business, even if you're not making a decision, that is under the law a board meeting, and that has to be properly noticed and open to homeowners. I have a slide in here, we'll talk about emails, but this extends to email discussions as well. Emergency board meetings can be held without 48 hours notice, but it should be an actual emergency. And boards can conduct business by unanimous written consent if necessary. That would be email vote. We'll talk a little bit more about that in just a minute, when you should use that and why you should try to avoid it as much as possible. And then regularly scheduled committee meetings must also be open to owners. So if you have a committee that meets regularly, like once a month or the first Monday of the month, that meeting has to be noticed. That meeting has to be open to owners, and minutes have to be taken. And so it's important to note that is why these days most architectural committees don't actually have meetings. They just review applications online, so they don't have to have open meetings and keep minutes and all of that stuff. Your notice can be made in any number of ways: publishing a calendar, putting it on the website, emailing, physical posting, mailing. Nobody mails anymore. That's just an unnecessary expense. But multiple forms of communication can help increase meeting attendance. We obviously post to your portal calendar. We email the community. You don't have to send out an email notice if you're just having an executive session, but you should still notice that on the calendar. Homeowners have the right to know the board's about to meet an executive session. Let's talk about email use. So again, you have the right to do unanimous written consent between meetings. That's usually an email vote. Too many emails or decisions made outside of meetings is a problem, though. It's a potential for challenge. It's something Arizona law and the legislatures constantly try to find a way to stop. Right now, there's no prohibition on emails themselves, but the legislature is keen on that, as I mentioned. In fact, there is a bill that is making its way through legislation this year that actually looks like it might pass. And if it does pass, it is going to ban email votes. Boards will no longer be able to vote on anything via email if this bill passes. That's somewhat problematic because things like insurance usually come in with limited time. And so we're going to have to call brief special meetings just for those purposes to vote on them should this law pass, this bill pass this year. But it is something the legislature does not like happening. They don't like boards voting via email. They want homeowners to be privy to all discussions and all votes. Emails outside of meetings should be either for administrative issues or votes only, not actual discussion. And then just keep in mind that emails can't be deleted once sent. They can be discoverable in court. It doesn't happen often, but every now and then in court cases, the other side requests all emails from whichever parties. Might be specific board members' email servers, it might be our servers. Those have to be turned over if so granted by the court, and the court usually grants them if requested. So keep in mind, whatever you put in that email could be discoverable. Don't talk bad about people in emails if you can help it either. That doesn't look good if you show up in court and they read an email that says, "Did you say in this email that John Smith was an idiot?" That's not gonna look good for the association or you. Along those lines, if you haven't done so already, we always strongly recommend that you create a separate email account strictly for association business, or at least use one that you kind of don't use for much else besides, whatever things you might sign up for or have you. Don't use your work email because I'm sure your work wouldn't be happy if they had to turn over email server stuff. So keep that in mind. All right, we're going to talk briefly about executive meetings. There are only 5 reasons under state law that you can go into an executive meeting. Those reasons are legal advice from the attorney, pending or contemplated litigation. I will say that this is probably the one that gives you the most flexibility. You can say, well, we're contemplating possibly taking litigation or going to litigation in this matter, but you shouldn't stretch the law if you can avoid it. Personal health or financial information about an individual member of the association, an individual employee of the association, or an individual employee of a contractor. Most of you don't have staff, so this one doesn't really apply, but the personal health or financial information about a member of the association does. That's why delinquencies, appeals, things of that nature are reviewed in executive session. There might be times you want to discuss an individual employee of a contractor. Your manager gets really sick and you want to talk about what you can do for them. You're allowed to do that in executive session, so you don't have to disclose their health issue, whatever that might be. The next item on here is matters relating to the job performance of, compensation of, or again, health records, or specific complaints against individual employees, if you have employees, or individual employees of a contractor. Maybe you have a complaint about your manager that you want to discuss in executive, you're allowed to do so. And then discussion of any member's appeal of a violation or penalty. So if a homeowner appeals, that is an executive session item. There is a caveat to that, the way the law is written. It is unless that member wants to be heard in open session. If they want to be heard in open session, you have to hear them in open session. I would say it's important to remember those 5 items, or at least a few of those 5 items later. The reasons you can go into executive meeting: legal advice, pending or contemplated litigation, personal health or financial information, matters relating to job performance, and then discussion of an appeal. Annual meetings. This is the owners' meeting, as you know, where owners get to vote for the board and any other issues that may come up. CC&R amendments. Last year, many of you had to hold a vote on whether or not you were going to continue your regulation over the streets, things of that nature. We always say that a properly run annual meeting really should be your opportunity to say, this is everything we have accomplished for you, we being the board and the community manager. So it's important to highlight items completed, goals and objectives, and your financial position. It's also a good time to bring in vendors if you need to talk about certain topics, or some of those collaborators like local police to talk about what's going on in the area. Last type of meeting, of course, is special meetings of members. Similar to an annual meeting, this is a membership meeting, but these meetings are called for specific or special circumstances, recalling of board members, governing document amendments, special assessment votes. If you can wrap those into your annual meeting, it's always less expensive to do so and encouraged, but these are reasons you might have a special membership meeting. We're almost done for the evening, but I want to quickly touch on two last topics: social media and then enforcement. Social media, so Facebook, nextdoor.com. We're all part of our neighborhood pages. The real question is, do we care about complaints and gossip that show up there? And what are best practices for utilizing that? If you talk to any of the attorneys in the industry, they will tell you they'd prefer board members stay off of social media. It is 2026. That is really an impossibility. So let's talk best practices. If you have people complaining on your social media page, we encourage you to respond with, hey, please report that to management. Here's their information. You should try to avoid getting into actual conversations, especially if a quorum of the board is chiming in, or you might run afoul of the open meeting law. But in general, board member statements can bind the association. There is a term called reasonable reliance. If you state something as a board member, somebody has the right to reasonably rely on that. So be careful what you put out there. It doesn't matter if you preface it with, this is just my opinion as a homeowner, not as a board member. The legal system doesn't view it that way. You're a board member 24/7. You don't get to say, this is just my opinion. This isn't me as a board member. And this is true for phone calls and one-on-one conversations with homeowners as well. We always try to say if a homeowner wants to meet, it should be the manager and a member of the board, or at least two members of the board, to avoid a future situation of he said, she said. Lastly, we're going to talk a couple of slides here about enforcement. Arizona is pretty big on fines not being a income source for associations. Fines and penalties are meant to deter behavior and gain compliance. If you didn't know, homeowners can get fined, thousands and thousands of dollars and never pay it, and there's not much you can do about it. You can take action if they remain in violation. But if they've corrected their violations and they just owe fines, you can't go after them from a collection standpoint for only fines. They have to be delinquent in their assessments and other fees related to their assessment. You can wrap fines into that at the end of the day, but if they only owe fines, you can't go after them from a collection standpoint. That's the way Arizona law has set things up. It doesn't matter that most of your governing documents state that fines are collectible like assessments. That's been overridden by state statute. So fines and penalties are meant to gain compliance. We always recommend that after a violation is resolved, if fines sit there unpaid for a while, you consider offering an amnesty offer to that owner and say, listen, you have $1,000 in fines. We'll waive $500 if you pay the other $500. The goal is to clear that amount from your books to make it hurt enough for them that they'll not hopefully have that problem again, and also to recover at least the hard cost that the association paid in sending out notices and all of that, hopefully more, but at least the hard costs. Make sure that in the enforcement time, you're giving people due process, appropriate notices, and an opportunity to be heard. All of you, as our clients, have a covenant enforcement policy. The covenant enforcement policy details all of these things, what the steps of the violation process are, their opportunity to be heard, what the period between notices is. So all of this should be set in stone for you guys, but it's important to understand that. Let's talk briefly about anonymous complaints. How do we handle those? Well, anonymous complaints don't work in the HOA world. Arizona law says we have to disclose, if so requested, the first and last name of the party that observed the violation. So you can't report your neighbor anonymously. We have a complaint form. If homeowners want to report their neighbor, they have to fill out the complaint form, which says, you are acknowledging by filling this out that we may have to disclose your name. And so that's what the complaint form is for. As officers of the corporation, you as board members do not have to fill out the complaint form. You can send us an email but you should absolutely include a photo. But you do also have to understand that we may still have to disclose your name. We tell both homeowners and board members that if you report a violation to us that we can go out during our next inspection and view, we're happy to go out and make sure we cite it on our own accord so we never have to reveal your name. But if it's not something we're going to see, like a noise complaint or something that only is occurring after hours, somebody keeps bringing a big rig to the community in the evening, it's never there during the day, well, we're not going to see those things. So those require a complaint. And then lastly, neighbor to neighbor disputes. We all like to say that's a neighbor to neighbor dispute. We're not going to get involved. And while that is largely true, Arizona law and case law that exists has kind of said, well, depending on what it is, you may have to get involved, especially if there's safety issues. So it's important that setting the tone with neighbors to understand how we're going to handle those issues and what's considered a neighbor to neighbor dispute. If we have two neighbors complaining about each other, eventually we're going to come to the board and say, board, we want you to make a decision that we can relay to these people that we are no longer going to take action against the other party based on complaints from the other party. Other neighbors are going to have to complain because you two are just going back and forth, basically. On the enforcement side of things, just want to recap your enforcement options. Yes, you have violation notices, you have monetary penalties. You can get your attorney involved. They can send demand letters. You can also file a notice of violation. Similar to a lien, a notice of violation sits on the home as an encumbrance, and when they go to sell the home, they won't be able to without curing that notice of violation. So there may be violations that communities run into from time to time where they say, you know what, we're not going to spend the money or time to fight this person to get rid of this shed they put up, but we want to record a notice of violation. So when they move, that has to come down or they won't be able to close on that home. The biggest step you could probably take is injunctive relief. If none of that works, the attorney can file a lawsuit for injunctive relief. This is where we ask the court to tell the homeowner, take care of this, or the court will give us another avenue to. We have a community that has done this successfully a few times. There's a couple of you out there, but the one example I like to give is we had a homeowner paint their house blue, not a nice blue, and they did it themselves and got paint on the windows, etc. I caught them when they were only done with one side of the house and tried to stop them, but they decided to finish. And at the end of the day, the association ended up filing for injunctive relief. The judge gave them 30 days from the date that he made his decision to repaint, or the HOA was allowed to repaint and charge him for it. And both the charge to repaint and all of the association's legal fees were part of the judgment and allowed to be collected on that homeowner. And that's exactly what happened. The association had to have the home repainted and that homeowner had to pay it all. They still live there, but they had to pay all of that because they didn't want to do things the right way. And then settlement agreements, as we mentioned, find solutions, find offers that work. Hey, we'll waive some of these fines if you resolve the violation, keep it resolved for so long, and pay the other amount by X date. Find solutions. And lastly, just wanted to touch on a couple case law things, which we've talked about along the way, but there are case law out there regarding associations and how they have to deal with things. I mentioned earlier that the CC&Rs or declarations are contracts. And so as a contract, Arizona case law has said that, it is a contract and it must be enforced like a contract. This is true for any CC&Rs. Associations also have a mandatory obligation to enforce, as we talked about. The case law that set that was Feller versus Scottsdale Vista North Townhomes. There have been other subsequent cases since then, but this was the original case law that set that requirement. It's not an option to enforce, and that was further taken in the next one there, enforce or amend, Johnson versus Point Community Association. So if you must either enforce your documents or amend them if they're not something you want to enforce. And so obviously that always begs the question, what if we can't amend? Well, you have to try to amend, and if you can't amend, you have to enforce. It's not optional. All right, we are now at the question time. Before I ask you guys for any questions you may have, I am going to ask you the questions I have. I do always at this point of the meeting ask everybody that to use the functionality in the meeting software. If you go to the reactions button at the bottom, there is a raise your hand. You can raise your hand. So what I'm going to do is, as I ask these questions, I'm going to ask you to use the raise your hand feature, and I will call on the first hand I see go up to see who gets these correct, and for some gift cards. I have $25 gift cards to hand out and a few questions to ask. My first question is, what are the 3 state statutes that govern HOAs? Oh, 2 hands shot up quickly. I have Gordy's hand up and Holly's, and I saw Holly's go up first. I'm going to call on Holly. Holly, go ahead and unmute yourself.
I think I'm unmuted.
Yep.
Preserve, protect, and enhance.
No, the 3 state statutes, not the purpose of community associations, but the 3 state statutes.
Big Bear, Small Bear, and Little Bear. I don't know. Skip me.
Okay, Gordy, do you know?
Planned Community, AG Condo Act, and Nonprofit Act.
Correct, Gordy. You get a $25 gift card. I'm going to ask a bonus question real quick here. Along those same lines, they were shown throughout the presentation. I didn't really talk about them, but I'm just curious if anybody knows what the Arizona revised statute numbers are for at least 2 of those 3 acts. So you'll see ARS, and then there's a number that relates to the act. Does anybody know what numbers relate to those acts? No, that is okay. I just wanted to see if anybody caught that. Really, I wanted to give another opportunity to give you a little bit of education. Anytime you see ARS 33-18, and it could be 1801 through like 1840, that is the Planned Community Statutes. 33-18 refers to the Planned Community Statutes. 33-12, and I think it goes 1201 through 1270 currently, that is the Condominium Act. So both the Planned Community Act and the Condo Act are ARS 33. Planned Community is 18 and Condo Act is 12. So 33-18, 33-12. The Nonprofit Act starts with 10. It's 10-31 through 10-38. So if you ever see those numbers come up, that's what they mean. All right, next question. Arizona law allows you to rely on information, opinions, reports, and other things of that nature if prepared or presented by another officer of the corporation that you believe to be competent, any of your experts or committees appointed by the board that you believe merits confidence. What is the statute or law known as? I got a hand up from Cal. Cal? You're still muted over there, Cal.
Safe harbor or business judgment rule.
Safe harbor or business judgment rule is correct. So Cal also gets a gift card. Thank you, Cal. I think Gordy just joins these so we can get a gift card. I don't think he's been to one he hasn't got a gift card at yet. All right, I have 2 more questions. Can anybody give me 3 of the 5 reasons you are allowed to go into executive session? Danielle. Appeal, yeah. 3 of the 5 reasons you're allowed to go into executive, and you got appeals, Yep. That's personal or financial information, so we'll go with that, yep. That's part of the collections. If they choose to. You got enough information there that I will give that to you, absolutely. The 5 reasons in a short nutshell are legal advice, pending or contemplated litigation, the personal health or financial information about a member employee or contractor employee, the job performance compensation or health records of an employee or contractor employee, and then the member appeal or penalty. So you got two for sure, and you listed other things that were part of that whole section. So we're definitely going to give that one to you there, Danielle. And so you're doing fantastic. Thank you for chiming in. Um, I am going to go ahead and give this next one to you, Holly, because you answered it. But my next question was, why do community associations exist? Do you want to reiterate the answer you gave earlier, Holly? Holly? That is correct. Perfect. And then our last question of the night is, when do meeting notices have to be provided? What is the time frame? And then what has to be included with the notice? Oh, Eileen has her hand up. Eileen? Eileen? You should be able to unmute yourself by clicking the little microphone kind of near the bottom left-hand corner. I sent you a request too.
48 hours before the meeting.
Correct. And do you know what has to be provided with the notice?
The time, the place, the agenda.
The agenda, correct. Yes. Perfect. Okay, those are the questions I had for this evening. I will get Gordy, Cal, Danielle, Holly, and Eileen all gift cards. And I appreciate everybody's time tonight. But before you're free to sign off, but now's the question portion. So does anybody have any questions we might be able to answer this evening?
Mike, I just had a quick one, and it has to do with, because you talked about violations, and if they don't rectify the violations, there's not a lot you can do to force compliance other than do that legal matter where you can serve an attachment for when a sale may happen. You used a shed example. What are what if you're not writing up compliance issues, or I think there's a lot of different things that you'll see on or a handful in a governing document that if you drove through the community, you'll see that violation all over the place, but nobody's getting notices. What happens to the board of directors' rights, or what does anything get diluted because you haven't enforced something in a long period of time?
Okay, good questions. I'm going to tackle this from a couple avenues. First of all, everything should be enforced if it's in your documents. It's what degree of enforcement. For instance, trash cans for every community are a common problem, right? Trash cans get left out after pickup day, etc. Those people should get violations. They should get fines. I would never recommend a board go to court for a trash can, and I'll tell you why. The end of the day is, if that homeowner walks into court and says, "Yeah, my trash can's been put away for a week," the judge is going to go, "What are we doing here if this is resolved?" The judge doesn't care that it might reoccur in a month or two. The courts often look at violations as, despite the fact that every community's documents has language about recurring violations, the courts often view violations as if it's been corrected, the next time it's a new violation. And so courts don't rule in favor of HOAs in those regards a lot. So for some of your, I'll call them more minor violations that can be easily corrected before court, such as your weeds, your trash cans, etc., I would strongly recommend that you continue finding them, but and maybe ask the attorney to send a demand letter, but you're not going to take many of those much further than that. If the home is really getting out of shape and they're not doing anything, with the landscape and the weeds are getting really tall, okay, well, now we might look at injunctive relief. But your options for filing a notice of violation that gets recorded on the home as an encumbrance, or for taking that injunctive relief step, those are often reserved for, I would say, your larger problems. Somebody's running a business out of the home. It's always the same types of businesses. It's an auto business. It's something that is creating noticeable noise and disturbances in the community. Or they've done things without approval. They've built something without approval. That they've repainted their house in colors that aren't approved. Whatever it might be. Or maybe their home needs painted and they won't take that step. Those are the bigger type items that you might go to the attorney and ask for a violation notice to be recorded and or for injunctive relief. Which direction you go is really up to the board. There is a very common misconception throughout the industry that my neighbor's always in violation and they're not getting notices. They probably are. They're just not taking care of the violation, notices and fines aside. And so some of those people, you really do have to, at some point, spend a little bit of money to take the extra step. It's important to note that, enforcement legal fees are not going to be collectible. You're not going to be able to charge them back to the homeowner unless you actually go to court and get a judgment. It doesn't really matter what your documents state. The law changed and was very clear last year that legal fees are only collectible if there's a judgment. So your documents might state that if you need to use an attorney for enforcement, those fees are collectible like an assessment. That's no longer the case. So you spend money to have the attorney send a demand letter and file for injunctive relief. You might not recover that. If you're filing for injunctive relief and actually going to court, you'll usually get your attorney fees awarded. If the homeowner fights back, you might not get your attorney fees awarded. But you got to, at some of those larger items, you have to resolve the violation at some point, which often requires taking those more drastic steps. Those should be a last result, but there are plenty of people who understand that you can't go after them from a collection standpoint for fines, and so they're more than happy to let you rack up fines because they know there's nothing you can do to collect those. But once you take them to court for the actual violation, that becomes a different story because the court can force them to comply.
Yeah, understood. This was, I know this was kind of more specific. It had nothing to do with the community I'm in for sure, but almost all of them have where you can't have your work vehicles, which is the way they work. The signs, right? You work for ABC Plumbing, it says ABC Plumbing on the side of your truck. Well, if every time was a new occurrence, they have a new occurrence every day because they leave in the morning for work and there's no violation. They come again at night, right? So it just seemed like there was no teeth to really do anything there. And I was just
You're
curious.
right. Those ones are tough. That's one of those things that we don't usually observe as management. So we're not citing. And so unless somebody's willing to complain about their neighbor, not much is being done. Or unless the association's willing to pay for evening, nighttime parking patrol. We have communities, including some board members on here, who have, nighttime parking patrol because they don't allow parking on the streets and for those types of things, recreational vehicles, commercial vehicles, etc. So the association either has to be willing to spend money on that level of enforcement, or neighbors have to be willing to complain. The HOA, the board itself is not in any danger of losing authority because they're not enforcing if nobody's willing to complain, or if you're doing enforcement. You've contracted management
Yeah.
to come out and do inspections during the day. If there's violations we don't see during the day, you're still doing a reasonable level of enforcement, so you're still fine. But those other things just aren't going to get taken care of, and people know. And we like to say, violations breed violations. So as those things start happening, it happens more and more. Similarly, home improvements breed home improvements. People start fixing things up, so do other people.
Yeah. Understood. Yeah, you answered the question. That was good. You don't really lose any authority. It's just some
Right.
things have a bit more teeth than others, and that's what it
Yep.
is.
Eileen?
Yes. If you grant an appeal to one homeowner and you have another homeowner in the exact same situation, does it follow that you have to grant the appeal to the other homeowner?
A great question. This actually is a similar question to if you grant a variance, do you have to grant another variance? And it all comes back to, does the HOA set precedents? And the truth is, HOAs do not set precedents in their decision making. So you can make a decision, whether that is to grant an appeal, whether that is to approve an architectural request for a paint color, or whether that is to grant somebody a variance on a violation, that later you say, we're not going to do that again. We didn't like the way that turned out. Or, we only did it for that person because of a very specific special circumstance, whatever. You do not have to grant it again. HOAs do not set precedents in their decision making. You are allowed to make a decision and go, that was not the right decision. We won't make that decision again.
Okay.
Right. Any other questions? Okay, if there's no other questions, I'd like to thank you all for joining us tonight and remind you that we have 3 more education sessions. Each of the next ones will also involve some different attorneys. Our next one is going to be the 2026 legislative update. We'll publish out that schedule again and then a specific invite for that one. But we do have, there's a lot of bills that are out there, but only a handful that look like they might actually pass this year. So we'll be providing some legislative updates and would strongly encourage everybody to attend that one when the time comes. But aside from that, I'd like to thank you all very much for your time this evening. You guys have been fantastic, and we appreciate your time. Hope you all have a wonderful evening.
Thanks, Michael.
Thank
Thanks,
you,
Michael.
Michael.
Thank you, Michael.
Thanks.